For the next panel, we'll have Professor Erika Gorga, the co-director of our new center and an organizer of the event. She's a professor here at FGV. She has also been a visiting professor at Vanderbilt Law School. We'll also have Professor Bruno Salama, also a co-director of the center and a professor here at FGV. Bruno has a JSD degree from UC Berkeley. And as a commentator, we'll have Professor Morgan Ricks from Vanderbilt Law School. Before joining academia, he has had extensive private sector experience in law firms, hedge funds, and most recently at the Treasury Department.
Okay, good afternoon. When I was a law student, I didn't like civil procedure at all. Okay, I thought it was too formalistic, very boring, and completely disassociated from the real world. Today, hopefully, I'll try to convince you the contrary. Okay, I'll try to convince you that civil procedure is very important for the business environment, okay, and for corporate governance. So this is a joint work I have been doing with Michael Halberstein, my colleague who has a degree from Stanford Law School. He has practiced extensively corporate litigation at Paul Weiss in New York and has worked in the in-room cases. And I myself also changed my opinion after doing some expert work for the Department of Justice on litigation related to Brazilian corporations. Okay, so scholars have tried to explain what variables are important for the development of capital markets and corporate governance practice. So that is a very famous literature that has focused on minority shareholders' rights, legal protection, and these scholars have raised the debate about the difference between common law systems and civil law systems, saying that common law systems are more protective to minority shareholders, and therefore they get better developed capital markets and credit markets. Others have focused on private regulations, such as stock exchange rules and the protection that these rules would afford to minority shareholders. Recently, there is a very important body of literature that argues that enforcement is really important. So it's not only important the law on the books you have, but how you enforce those laws. And for that purpose, you can rely on private enforcement and liability rules. And some other scholars will say that you rely mostly on public enforcement through the state and the judiciary power. Okay, interestingly, this literature has surveyed and analyzed several features of civil procedure, especially who can file a claim, what are the filing mechanisms available, where there are, for instance, class actions in a particular country or derivative suits, how attorneys charge their fees, litigation costs, how they are allocated among the litigants, and there has been some discussion on changing some rules to make possible class actions and therefore discussing how the American rules on fee shifting and contingency fees play out for those particular suits. What I claim in this paper is that strikingly absent from this all literature that talks about enforcement is a particular analysis of how civil procedure really works to make these suits effective. Okay, so the thesis of this article I'm going to present is the significance of civil procedure for corporate law and corporate governance. And we are using as a case study the US style civil litigation, okay, the discovery system. And we are saying that is one of the critical features that can explain corporate law evolution and corporate governance in the United States. And of course, later on, I'm going to say about how it impacts Brazilian law and emerging markets law in general. Okay, but here is why civil procedure is very important. Okay, civil procedure affects corporate litigation and litigation outcomes. So basically, if you are a minority shareholder and you have shares from a publicly held corporation, the controlling shareholder has approved a transaction, a self-dealing transaction with huge conflict of interest. He has expropriated your value, your money. Okay, you have lost your investment. What do? You have to file a claim. You go to the judiciary and file a claim. How can you prove your case? Okay, this is the heart of the civil procedure system. The mechanisms you have in place in a particular country that will enable you to prove your claim. And when we look at civil procedure systems across countries, they are strikingly different, okay? You have, of course, the classical common law and civil law divide, but it's not enough to explain the difference in civil procedure systems, because you have like the US and the UK that are both countries from common law system that have completely different types of civil procedure. In this paper, of course, we are using the US civil procedure system as particular example, and we are claiming, we are explaining how it has shaped the landscape for corporate law and business evolution in the United States. So basically, we have here the historical roots for the federal rules of civil procedure. And it's very interesting that when corporate law scholars talk about New Deal regulation, and everyone has looked at New Deal regulation because New Deal regulation came out just after the crash of the New York Stock Exchange in 1929, and then corporate law scholars will say, okay, so we have securities law regimes that was enacted in 1933, and then we have securities and exchange law regime that was enacted in 1934. Okay, so that was the rationale of providing information to investors, okay, making the market more transparent with the establishment of this securities regulation. But everyone forgets that at the same time, or a little later, there was also a procedure revolution taking place in the US that was following exactly the same rationale. Okay, meanwhile, the securities exchange rules require corporations to provide information ex ante before they make IPOs in the market. The civil procedure regulation was designed to arm litigants with broad, vastly expanded investigatory powers so that they could obtain information on corporate internal procedures, activities, and decision-making in case of corporate wrongdoing. Okay, so this is the origin of the civil discovery regime. So it had the same realist philosophy that transformed the federal regulatory system in the US, and it followed a rationale that the government should provide the tools in a very rational way, scientific way, so that the decision will not be based on what the judge has eaten for breakfast. No, so the judge would have to decide based on specific facts that were investigated regarding a particular case. Of course, a caveat here is that there are many critiques to the discovery system in the US, and we are not at all claiming that that system is perfect or doesn't have flaws. It's actually very expensive, and we don't take that specific approach in the paper. I think there has been a lot of literature criticizing some specific features of the US discovery regime and the strike suits that it generates. But here in this paper, we're trying to look at another perspective and see how it has shaped the evolution of the US corporate landscape. So basically, what does discovery do? It gives parties access to all relevant information before trial. So, it encourages this rational assessment of the value of the case. And also, one of the rationales, and it's very important to see when you look at the historical filings, is that it was designed as a way to increase the settlement rates before trial, so that parties would have access to all relevant information, and if they don't want to pursue the suit, they could settle the case and negotiate ex ante whatever they find would be a good outcome for themselves. Okay, what are the particular features of civil procedure? Okay, very broad definition of relevance. So basically, a party can have access to whatever is relevant to that case. Methods employed, depositions, you have the adversarial design. What is it? It's a party-on-party investigation. Basically, I don't need the judge for getting access to the other party's documents. So the judge will only authorize parties to proceed with discovery, and then attorneys will receive subpoena power so they can investigate the parties. Okay, so what will this generate? This will generate that every document, electronic record, and communication between employees, managers, executives, and board members may have to be reviewed in litigation discovery on short notice. So the scope of such investigations into corporations' internal affairs can be very extensive, covering several years of operation. So executives have to watch out what they do, because they can be deposed. And if they are deposed, they can be in deep shame. So basically, attorneys are giving the subpoena power independent of the presence of the judge. So parties swear under oath, and therefore they can give their testimony, and this testimony can be used later on for trial. So this is exactly what is discovered. It's this system of adversarial party-driven fact investigation that has become the focus of US civil litigation. It's unique, and it has generally no functional equivalence in civil law jurisdictions. It's very hard to appreciate the difference. You have to look very carefully at the level of details. But regarding the power division, so meanwhile in the common law system, the US system, you have a lot of power devolved into private parties. In the civil law system, you have the judge controlling the civil procedure. So basically, you have different incentives going on, because private parties have the right incentives to pursue their claims, and the judge not necessarily will have, because the judge may not want or have the time to be able to conduct all factual analysis, all factual investigation necessary in a case. I want to focus in one particular example. There are many examples out there. I like very much the Disney litigation. Okay, and the Disney litigation exposed some of the very important corporate governance failures in Disney. So basically, the story is that Disney's board gave a severance package to Michael Ovitz, departing president of the company, of approximately $140 million after just 14 months in office because of an early termination provision. Of course, shareholders were not very happy. Okay, you're paying this amount of money. The guy has only stayed 14 months here. Okay, what can we do? They file a derivative action based on waste, and they complain that the board's approval of the excessive protection did not comply with the fiduciary duties. Okay, what it has generated. So the trial lasts 37 days and included 24 witness examinations, generated like almost 10,000 pages of transcripts. So you have every detailed review of every piece of information that happened inside Disney Corporation for the board members to take that decision. Basically, the phone calls between the board members, between the board members and the chairman, they were all subjected to scrutiny. They could reconstruct how all the process occurred, what was the opinion of the consultant, all the tables and spreadsheets that you were used to make up the compensation package, and all sorts of details. The opinion of Chancellor, the Delaware Chancellor that decided the case, is a 250-page opinion on its decision after trial. And from this 250 opinion, 174 pages is just reciting the facts of the case, just talking about facts. Another 45 pages analyzing the facts in light of applicable law, and only 22 pages reciting the law. Okay, so which shows how it's important to have a discussion about what really happened. Okay, if we look at civil law jurisdictions, as I'm going to argue in a minute, the proportion would be exactly the contrary. A judge can spend like 200 pages discussing the law, completely in abstract of the fact, and maybe, you know, in one line or two or three, and mention the facts very, very fast, so that, you know, it doesn't really bother too much. The claim of the paper is that discovery enables this disclosure of internal corporate practice that would otherwise not be revealed to public scrutiny. And it's very difficult that this type of facts that are currently revealed in a lawsuit in the US would be revealed in any other jurisdictions. And we have made a research, and our paper covers that on particular in Germany and Brazil, and we show that more extensively in the paper, that the rules are completely different. What are the impacts for corporate governance? Basically, we explain the paper. I don't have time to go through all the details of the claim, but basically we explain that the threat of discovery and discovery itself affects the development of corporate litigation in the US, the evolution of case law and judicial precedents, the private rules of corporate governance themselves. So, for instance, the issue of executive remuneration was not that big deal before the Disney case. So, after the Disney case, everyone started discussing executive remuneration. Of course, the case was cover story of the leading magazines and newspapers. You have also the development of securities law and corporate law, because once the regulators started to realize that the companies were practicing that level of executive remuneration, okay, what should we do when we have a crisis? Oh, we have to pass a law asking people to report, ask corporations to report the level of remuneration that they practice. So this piggybacks on the disclosure rules of the Securities Exchange Commission. So we argue in the paper that the discovery in civil procedure allows and influences this culture of American corporate disclosure and transparency of information. So it's a complementary relation to periodic disclosure. Public disclosure would operate ex ante. Okay, when nothing goes wrong, I have to make an IPO, I have to raise money in the markets. Okay, I have to file a bunch of information with the Securities and Exchange Commission. Okay, and what if something goes wrong? Okay, what kind of specific information we would have that corporation to disclose, that corporation that has engaged in a particular fraud? Okay, that is only possible through discovery in a civil litigation. So it really enables this to fulfill the asymmetry of information in an ex post period. Okay, we also develop in the paper the idea that it's actually it has effects on very different cases, independent of the outcome of the case. So when you look, like Disney was a case that went to trial. Okay, this was the question we have got from other people in other places we have presented the paper. What does it happen if the case is not, it does not go to trial? Cases that get settled, for instance. And we have a case study in the paper, a very interesting case study about the Bank of America settlement that shows that after extensive information that the parties got from each other in this back forth of information allowed by the party investigation, the case was actually resolved in settlement, but the value of the settlement was much, much higher than the value that was proposed before the information was reviewed. So basically, shareholders could have access to information that the board of Bank of America, in the Merrill Lynch case, in the Merrill Lynch acquisition, they did not comply with all possible fiduciary duties that they should have been complying with, and therefore they could extract a much higher settlement. Also, look at Carmark. Carmark is a very interesting case. It's one case precedent in Delaware that is very famous for the oversight duty. Okay, but Carmark is also only possible because you had extensive discovery on that particular case, showing what were exactly the actions that the board has taken in that particular situation that was being questioned in Carmark. What about cases that are dismissed based on the Special Litigation Committee under Zapata or Aronson? This is very particular of the US. I'm just going to mention very quickly. Is before going to trial, there is a possibility of having a Special Litigation Committee analyzing the corporation to see whether the Special Litigation Committee thinks that the board has done everything right. And this procedure, we argue in the paper, also mimics a little bit discovery, because the corporation is going to review all documents and is going to depose relevant people. And this, even if the trial, even if the case does not proceed, this also can generate corporate governance improvements, because the judge, when it approves a settlement based on Zapata or Aronson, it requires corporations to have showed that they did investigate themselves. So it has a deterrence effect, it disciplines the entire corporate hierarchy, and it leads to some corporate governance improves. So here I just present you a couple of precedents, like Van Gorkom, also very important case on the business judgment rule, where TransUnion acquired, there was a transaction between Van Gorkom and Jay Pritzker, and also all the information you have available in that case, the price they paid for the corporation, how much time they negotiated the deal, whether the transaction was fair or not, whether they relied on the opinion of the investment banker or not. Everything is, you just get this type of information because you have the discovery process, okay, in civil procedure. So it generates a lot of corporate governance recommendations and changes in corporate governance culture. Compare the civil law system. I'm going to run here because I think this is the most important part for the purpose of civil procedure in Brazil. My question is, could a case like Disney be replicated in a civil law jurisdiction? Clearly not. Why? Because we have a centralization of the judicial process. All our Brazilian civil procedure code, and it's important to note that this is not exclusive of Brazil, because the Brazilian civil procedure comes from the Italian civil procedure, as you know, all witness testimonies are taken before the judge. So therefore, the judge has very little incentives to conduct extensive investigation. The judge has no time, has many other cases to judge, and why will bother with that specific corporation? Also, plaintiffs are allowed, this is a matter of principle in civil law systems, they are allowed not to produce proofs against themselves. This is Brazilian Civil Procedure Article 347. So basically, Eisner and Ovid, two of the main characters that were involved in that Disney dispute in the US, they would not even be considered witnesses in Brazil. Another interesting point is that plaintiffs in Brazil must list and describe with specificity all the defendants' documents to which they want to have access. They have to list, as simple as that, as if they knew what they could list. Relevancy is defined very narrowly. So I here have a quotation from the Brazilian Civil Procedure Code, Article 356, and look at what it says. The complaint made by the party shall contain the specification as complete as possible of the documents. Our civil procedures presuppose that someone is looking for a document, a piece of document, and not a whole bunch of documents. The objective of the proof indicating the facts that relate to the document or thing and the circumstances that support the plaintiff's affirmation that the document or thing exists. So how can shareholders of a public corporation know what kind of documents could exactly exist, and how can they list in the judicial procedure in Brazil? That's a very interesting question. Perhaps they could rely on some sort of magic. Policy arguments that we propose in this paper. First of all, when we analyze corporate governance and corporate litigation, and even arbitration, because now many corporations under the Bovespa new rules, new segments of corporate governance are subject to arbitration, we have to see what are the kinds of proofs that are allowed in that particular system of dispute resolution. So we have significant differences in fact investigation and analysis between common law and civil law systems. You can look just at the number of factual pages and descriptions to see it's very evident how each system is very different. We believe that civil procedure is a very important feature because it allows generation of proofs. Many of the cases here that happen of frauds, Novo Mercados, I'm talking about Agrenco and some other cases, the cases were dismissed for lack of proof, many of them. And right now, when Europe is considering adopting mechanisms of class action and derivative suits, and sometimes we hear scholars proposing that other countries should adopt class action and derivative suits, according to the US model, we have to say, be careful, okay? Because even if you implement the suit or you enable parties to file the suit, it doesn't necessarily will produce the same outcome because you don't have the supporting rules that would allow that suit to use the mechanisms of investigation. Okay, thank you.
The standard situation where we have to thank the organizers for setting up the conference, which places me in this unusual situation of having to thank Erika for putting together this conference, and at the same time being myself only formally an organizer, having to thank everybody for being here. So let me take the opportunity once again to congratulate Erika for putting together this conference and on this rather curious role of thanking everybody when you have done nothing. Thanking you all for being here, and in particular my colleagues Viviane Prado and Luiz Estelita, who are colleagues here and came over to listen to us. The topic of this talk is the extreme levels of litigation in the Brazilian financial system, which we metaphorically call citizens versus banks in the Brazilian financial system. And these extreme levels of litigation that, as I will show you, prevail in Brazil are an object of interest, I suppose, for two reasons. First is because it's just curious or funny to see just the size of the phenomenon that I'm talking about. So let me read a small paragraph from the paper. For many years, Brazilian financial institutions have been involved in record high levels of litigation. A recent study showed that financial institutions are currently the largest private litigants before Brazilian courts, having been involved either as plaintiffs or defendants in almost 13% of all new lawsuits brought before state courts in Brazil in the year of 2011. And this percentage increases to almost 15% with financial institutions as defendants, in most of them, by the way, in the state small claims courts. And then there's lots of data showing that basically financial institutions are a huge customer, so to speak, of the Brazilian judiciary power. And just to put these numbers in perspective, the second, so to speak, customer of the Brazilian judiciary power are the telecom companies, which every Brazilian has come to hate because their service is lousy in this country. And yet, banks are a party to a litigation 4.5 times more often than the telecom companies. So it is really just astonishing. And as I said, this is interesting just because it should be the object of curiosity. But aside from that, it seems interesting for another reason, in the sense that, as I will explain, it sheds light on the place of Brazil in the recent financial crisis, or perhaps more presciently, it can illuminate or add to some literatures that value case studies. So I mentioned in the paper 3 of them. First of all, there's a debate about the role of courts in the so-called geopolitical South. So there is a booming literature on the role of courts in countries that have recently democratized, ranging from, say, from Turkey to Colombia, to other countries in Asia and Eastern Europe and so forth. Second, there's also a quite interesting literature that values case studies called the institutional variety literature that uses case studies to try to understand the ways in which institutional framework and policy play out, particularly in the developing world. And third, there is an old literature that has basically come to exist since law and economics has been set up, which is the literature that discusses the relative advantages of the judiciary power vis-a-vis the regulators and vice versa. And this is in fact a literature that Professor Aloysio Araújo has touched upon. And you know, basically just to sort of give you my basic take on this literature is that for many years, scholars that have some sort of affinity with law and economics have come to conclude that courts tend to do a very good job. This is, of course, originally the thesis from Richard Posner, and it still resonates today with lots of literature. And I think that the piece that Erika has just presented to us, in a sense, is still sort of an offspring of this earlier insight. But if you look at the work that is being done by people such as Schleifer, there is a revived debate about whether courts can indeed perform better than regulators. And of course, there's also the issue of relative cost. In any case, I think that the sort of story or narrative that I will formulate here, it's less than a theoretical argument. It's more a narrative. It should be hopefully useful in these 3 streams of literature. So I think the background story here is the conventional story of Brazil and the crisis. And if we were to summarize it with the actors that I have in mind, regulators and the judiciary power, we have on the one hand the tale of a heroic regulator in Brazil, so to speak. It has become the, let's call it the conventional wisdom that our banking regulators did an outstanding job before the crisis. Uh, and at the same time, it has also become conventional wisdom that our judiciary quite often does a lousy job. So the story of the heroic regulator, the story of the heroic regulator it can be basically summarized on the idea that the Brazilian central bank kept Brazilian banks highly capitalized and basically far from the poisonous, toxic CDOs that were being issued mostly in the United States and that contaminated the financial systems worldwide, including the European one. And the Brazilian regulator kept the Brazilian system lowly leveraged and highly capitalized. So that's, you know, that's basically a pillar of the conventional wisdom. And the other pillar is that our judiciary does mostly a lousy job because it has it's slow, it's uncertain, and most interestingly for the topics that I have at hand here, it is argued that it has an anti-creditor bias or anti-investor bias that drives up litigation by enticing opportunistic litigation and causing adverse selection problems in the financial or in the credit system by driving away good borrowers and bringing into the system bad borrowers, driving up interest rates, and you know this is a fairly straightforward story. So I basically the purpose of this article, I should have mentioned it earlier. It's not my article only. It's an article I co-authored with Tiago Jabor Pinheiro, who sits over there. So you know the mistakes are all his, but in any case, so you know the tale of the heroic regulator. Let me before I get to my argument. Okay, let me give you my argument before I make the footnote that I was going to make. The basic argument here is that we want to challenge this framework. We basically are not so confident that the Brazilian regulator is that heroic. We believe that his correct actions have been part of a larger structural framework that created incentives to it to act as it did on the one hand. And on the other hand, likewise, or in parallel, we're not claiming that the judiciary power is heroic, but we also claim that there are similar structural conditions that have created positive incentives for the regulator have in the Brazilian circumstance because of its circumstances created negative incentives for the judiciary in some cases. So we basically try to build a narrative of a broad institutional hypothesis or institutional narrative that traces this high levels of litigation to underlying structural determinants, call it institutional drivers, if you prefer. So this is our argument, and before I will articulate it in any detail, let me get back to where I started, which is the notion that we have a heroic regulator. I have written in the past, and this is not in this current paper, my take on the tale of the heroic regulator, and basically I think it exemplifies the conventional knowledge or wisdom that success has many fathers, but failure is an orphan. Because you know it is indeed the case that Brazil did escape from the worst aspects of the severity of the international financial crisis, particularly until 2 or 3 years ago. And it is indeed the case that the Brazilian regulator did keep our system insulated from the possibility that, say, Brazilian banks could have purchased toxic CDOs from the US. But on the other hand, the industry that was being regulated by the Brazilian regulator, the central bank, had never in the first place asked it to allow it to invest in CDOs because it didn't need it. Because the Brazilian financial industry has attained higher levels of profitability in comparison to its international counterparts without having to do any kind of financial innovation. So let me say the same thing in a very provocative way. While the subsidy or the bailout of the financial industry in the United States came ex post after the party was over, the bailout of the Brazilian financial industry came ex ante every month in the form of high interest rates, which we have had historically. So, you know, there's nothing heroic here, and this is where I will connect this older argument with the argument that I'm making now. There's really nothing heroic here on the part of the regulators, and perhaps there's much less villainy that is often attributed to the Brazilian judiciary power. And what we have here, as we believe, is very powerful structural elements that have been conducing the Brazilian financial system to behave the way it is behaving. And here's the case, here's the where we get back to levels of litigation. The high levels of litigation that we have in the Brazilian financial systems are an structural element of it, and it's a bizarre situation because it's a sad fact. You know, it means that we have a dysfunctional system on some level. The high levels of litigation, I'll repeat the argument, are structural or endemic as opposed to circumstantial. So while you have peaks of litigation in the financial industry, for example, this is the case in the United States because you have higher levels of litigation, you know, connected to misdeeds during the past 5 or 6 years or so. High levels of litigation are a part of the Brazilian financial system as it is. So why is this the case? Well, here I'll try to be as synthetic and brief as possible in basically laying out the details of the argument. On the one hand, we're trying to think about a perverse historical legacy that we have in the Brazilian financial system. So a perverse institutional letdown that is historically rooted. I'll repeat, a perverse institutional letdown that is historically rooted in the Brazilian financial system. So there are many ways to carry out this narrative, and the way we do that is by focusing on the way in which the central bank has happened to come about in the mid-60s and the way in which it has been transformed to exercise the kind of roles and that it exercises today. The Brazilian Central Bank was created in 1964, but to be a little bit provocative in the argument, it has not been a central bank until the mid-80s. It was just a building. It was called the Central Bank of Brazil. There were a bunch of people there talking about things such as foreign exchange regimes, but it wasn't a central bank. Why was it not a central bank? Because it didn't have power to do monetary policy. It didn't have power to do monetary policy for many reasons that have to do with the way the military regime handled the country, but was epitomized by what was called the conta movimento. So the conta movimento basically meant that the Banco do Brasil, which is a large federal bank that has existed in Brazil forever, could lend as money as it wanted without having the funds to do that. The only thing it had to do was to make this accounting move in the central bank accounting. So basically, the Banco do Brasil lends the money, and then the central bank immediately has to fill in the money that the Banco do Brasil has loaned, but it didn't have. So, you know, the central bank could not do monetary policy just because it failed to have the basic instruments to do any sort of control of the money supply. And so, why does this matter if we're talking about litigation? Because the history unfolded in such a way that in the mid-80s, in the middle of a democratic, in the middle of a democratic transition, to take care of inflation, the central bank had to raise interest rates, and the interest rates have been very high ever since. And so I told you this story basically to say that litigation can be attributed in part to a legacy of a central bank that first didn't exist, and then when it came to really exist, it had to raise interest rates. And well, what does one thing have to do with the other? Why do interest rates have anything to do with litigation? Just because it is very different for a judge to rule on a contract where the interest set out there is 10% per year versus a contract where the interest rate is 10% per month, which is very often the case in Brazil. So it has the historical circumstance in Brazil is such that interest rates have become extremely high. It has nothing to do with whether the central bank is a hero or the opposite of a hero of violence, but it is our underlying circumstance that we call the incomplete normalization of the economy and to some extent of politics. Now, so this is basically, you know, the first part of our institutional hypothesis or institutional narrative, however you want to call it. And the second part is we try to pinpoint more specifically what we call institutional determinants of litigation in Brazil. And then we ask the question, you know, not how the courts behave the way they behave, but why do so many lawsuits actually reach the benches of our judiciary powers in the first place? And then what we're driven to is to a much broader agenda than the one that is currently being discussed in Brazil. The existing agenda tackles mostly civil procedure issues and collection issues and bankruptcy issues, and we claim that the problem is much deeper. So without getting into much of the details, we believe there are economic, political, and strictly legal drivers of such litigation. On the economic side, we have just the macroeconomic problem that is largely unsolved, and in many instances, the look at the institutional problem narrowly understood is really escapism, because the problem of high interest rates in Brazil is, at the end of the day, largely a budgetary one, and it has to be solved at some point. And institutions is evidently part of the story, but it's a part of the story, and definitely not the whole story. On the political level, we want to point out that the judiciary power in Brazil has come to play a very central role in our scheme of political powers, one that is incomparable to what it has exercised in the previous history of Brazil, and in comparison to the judiciary powers in other places, I will claim a much more prominent one. And then, you know, we sort of start listing lots of things. I'm told my time's up. I wouldn't want to go into the details, because each one of this, you know, economic, political, or legal determinant has a weight and a story to be told. But let me tell you the basic conclusion of the paper, and so we wrap up and we can hopefully have a few moments of discussion or Q&A. So we argue that the democratic transition in Brazil during the 1980s resulted in a new economic, political, and legal context that clashed with the institutional setting of economic policymaking inherited from the years of military dictatorship. The explosive level of litigation that has now come to characterize Brazilian financial markets in general, and credit markets in particular, is not simply the result of poor procedural and civil laws, but rather an institutional byproduct of an unfinished transition. The key lesson is that high litigiousness became an impediment to the full normalization of the Brazilian economy, and that reforms will be at best partially successful unless they recognize, understand, and address the background institutional drivers of financial market litigiousness in Brazil. Thank you.
Hi, Morgan Rex Vanderbilt. Well, I'm delighted to be here and really in a happy situation to be commenting on these two papers because I think they're both really remarkable papers, and I don't say that all the time. I learned a lot from both. I learned a lot from both of these. From both papers, you know, I'm not a procedurist, so I hadn't thought about discovery in quite some time. And I also, I do spend a lot of time thinking about monetary institutions, but I'm not an expert in the political, legal, economic history of Brazil or the Brazilian central bank, so I learned a lot in that area as well. So I'm going to be pretty brief and pretty positive, although I'm going to offer some critical thoughts on both papers. So the Gorga Halberstam paper, I found more convincing on the second read, and I mean that as a compliment because I found it pretty convincing on the first read too. But usually I find on the second read that I am less favorably inclined toward the argument of an article. But this one was even more convincing the second time. The idea that litigation discovery is an important legal variable in capital market development, I think they make a really good convincing case for this, and it appears to be a novel case. I don't think that this argument's been made before. It certainly hasn't to my knowledge. The disciplining function of litigation is of discovery procedures in the U.S. are pretty apparent, and I think their case studies are really nice. I mean, if you think about what Erica said, that Eisner and Ovitz in the Disney case couldn't have been forced to testify in civil law jurisdictions, I find to be kind of a remarkable thing. And also the fact that you need to ask for, in document production, ask for a particular document with particularity. The standard is that you're asking for the document. That's just not the way it works in the U.S., and it's hard to conceive of how one would construct a record of a process that a board or management team undertook in the absence of the ability to do those things. So I find that utterly persuasive. And although she didn't emphasize it in her talk, for me, one of the key insights here was the importance of defensive discovery. The very allegation of wrongdoing, even if a case doesn't go to trial, even if it's settled prior to a motion to dismiss, will lead to a firm having to effectively hire outside counsel to go do discovery on their own. And you're bringing in outside professionals with their own professional standards, their own legal responsibilities, their own reputational consequences to look in detail over the emails and other records of the company has to impose a great deal of ex-ante discipline on the management team. Irrespective of whether a case actually goes to trial, if there's a special litigation committee, that special litigation committee, as Erica pointed out, is going to need to demonstrate that or argue that it made a reasonable investigation, which means doing something like defensive discovery on your own. So the very prospect of discovery, I think, does generate, I think the paper convincingly shows, generates some disciplining function on the management team that it's hard to imagine would exist in the absence of those procedures. So kudos to the authors for this paper. I'm going to offer three brief criticisms. One of the arguments is that discovery actually affects substantive doctrine. And I found this to be interesting, but I wanted to hear a little more. So in the U.S., the business judgment rule, one of our core fiduciary duty rules, is really a process-based rule. It says that it doesn't review the substantive outcome of a board's decision, but rather the process that a board undertook in reaching its decision. I was left wondering whether that is different in other countries. In other words, whether fiduciary standards are more based on substantive outcomes as opposed to process in other countries. That would have convinced me even more that the discovery was itself responsible for the ability to have a process-oriented standard. And I don't think the paper made that particular case, so that was something that left me hanging a little bit. Second, the idea that litigation discovery complements and enforces periodic securities disclosure didn't resonate with me as much because they seem so different in kind to me. Periodic disclosure is mostly about the performance and prospects of the business, whereas litigation or discovery in general centers around allegations of wrongdoing. And there seems to be a difference in kind there that that particular point didn't resonate as much with me as some of the other points in the paper. And finally, on the transplant question, so part of the argument here is you can't transplant U.S.-style corporate governance rules without also being mindful of the information forcing regime that's entailed by U.S. discovery. In principle, there's no reason you couldn't have a very robust information forcing regime in a civil law jurisdiction that's in a judge-run circumstance. I mean, it would require greater resources. There's no reason in principle that the desire to do one's job well wouldn't cause judges and their assistants, et cetera, to do a good job with litigation discovery. So in terms of implications for transplanting corporate governance rules from the U.S. abroad, I think it's worth acknowledging that that it's not necessarily adversarial discovery, but a robust information forcing regime, and that one could, at least in principle, imagine one in a civil law jurisdiction. So that concludes my thoughts on Professor Gorga and Halberstam's paper. Professor Salama and Pinero, an equally impressive and thought-provoking paper. So the claim that we need to look at the broader institutional context to explain credit scarcity and credit litigation, the prevalence of credit litigation, or financial institution litigation, I'll say, in Brazil, is broadly convincing. And so I have three main critical observations here. First, just on the positive observation that there are alarmingly high levels of financial institution litigation in Brazil. So and you read the paragraph out earlier. Just the observation that some percentage, say 13% of federal or state, I'm forgetting, but cases or civil cases involve a financial institution wasn't quite enough for me to convince me that there was something extraordinary here. I mean, if you take every industry in any jurisdiction and rank them, there will be one that has more litigation than all the others. And I would suspect in the U.S. it's also the financial industry. So the fact that it's significantly higher than the telecom industry, you mentioned that people are very unhappy with their telecom providers often, but that doesn't necessarily convince me that it is alarmingly high. One thing worth thinking about is whether there's a way to do a cross-country comparison to show that Brazil is really exceptional in this regard. But I'm sure that's correct. So I was willing to take the author's word for it, but I was looking for a little more empirical basis for the claim. But let's assume that the claim is correct. So the second thing I was left wondering here was, to what extent do those who adhere to the conventional wisdom here, to what extent would they really disagree that there are broader structural problems that are partly responsible for scarcity of credit and for financial institution litigation? So these aren't either or, right? It could both be that that the law or the judiciary is very pro-debtor, or not particularly keen on a creditor protection. And it could also be the case that a history of political and economic and legal circumstances have led to, in particular, high interest rates that lead to a fairly scarce credit environment. So to be a little more particular, so our keynote address this afternoon noted that the reform of the bankruptcy regime, I think it was in 2005 if I read the slide correctly, coincided with a pretty remarkable shift in credit availability for businesses in Brazil. So our speaker showed that coincident with that change in the bankruptcy regime to what I think is fair to say, a more creditor-friendly, or at least a more efficient regime that acts within 4 years instead of 10 years, if I'm remembering correctly. That institutional change coincided with a very dramatic increase in business credit to GDP, also in lower spreads in the credit markets, although we didn't see empirical information on that, but the speaker mentioned it, and longer-term, greater availability of longer-term credit in the Brazilian credit market. So if those things are true, that's the conventional wisdom story, right? That to a certain extent, that the lack of creditor protection and legal uncertainty in Brazil has a causal relationship with the scarcity of credit and high credit costs. Is the view that you're offering an alternative to, or at least a supplement to, but my simple point is that they're not mutually exclusive. It could be the case that it's true that the bankruptcy reforms improved credit availability to businesses, and also that there is a broader cultural, legal, economic, and political history that has caused high interest rates and scarce credit. My second point, or my third and final point rather, is about bank disincentives to supply credit, which is one of the arguments in the paper, although you didn't emphasize it in the talk here. You make the point that returns on sovereign credit are pretty high because interest rates are high, and therefore the banks have been able to earn high returns without providing credit to private borrowers simply by using a significant portion of their balance sheet to invest in sovereign credit. And also that regulatory capital tends to incentivize banks, and this is true not just in Brazil but elsewhere. If sovereign bonds get a 0% risk weight, then banks are incentivized to invest in sovereign bonds. But there is an underlying assumption here that, well, let me put it this way: if banks weren't funding the sovereign credit, then someone else would have to, presumably. And if there is that someone else there that will be willing to lend to the government, the alternative to the banking system lending to the government, then we need to understand why that alternative source of financing won't lend to private businesses and consumers. So there may very well be a good explanation for that maybe international sovereign debt investors would be willing to hold a lot more Brazilian sovereign debt, but they wouldn't have the ability or willingness to own private securities issued in Brazil. But I think that step was at least missing from the argument. And this relates to the U.S. debate, macroeconomic debates over austerity in the past few years, and the question of crowding out. So advocates of austerity, fiscal austerity in the U.S. have persistently argued that the deficit financing by the federal government means that we're issuing so many bonds, the sovereign is issuing so many bonds that that credit is crowding out the borrowings that would otherwise be made by private investors. In that sense, fiscal deficits are hampering the economic recovery. And the argument that the authors here are making starts to feel like it's shading into a crowding out story a little bit, and I would at least be cautious about. It is a crowding out story, but it's a bank-specific crowding out story. And so the answer to the crowding out story in the U.S. was not that we should change regulatory capital rules or reduce interest rates. The answer to crowding out, at least in the U.S. context, was the government should spend less and stop borrowing so much. So it was a fiscal argument as opposed to a monetary argument. anyway, it's something worth thinking about. And that concludes my comment, so thank you.
One of the things we see increasingly in the U.S. litigation system is a move away from using the court system and a move into the private arbitration system. And increasingly, the Supreme Court has endorsed arbitration as an alternative to class actions, particularly in the context of consumer claims. But one strong trend in the area of corporate litigation is the use of what are called forum selection clauses, which essentially limit the forum in which the case can be brought. They're analogous to arbitration clauses. They're slightly different in that you can still use the court system. But do you have any reaction to how that affects your thesis of your paper?
Randall, thank you very much for your point. I think I need to study a little more this subject to be able to provide a full answer. But my guess is I'm going to use an analogy with the problem we have now in Brazil. So right now we have Novo Mercado, as you are very familiar with it. It's a dual regulatory regime that the corporations have opted out from judicial system. Allegedly, this would protect more minority shareholders. We have seen quite numerous now, significant number of frauds in companies listed at Novo Mercado. I can tell you a very recent example, Cruzeiro do Sul Bank, Pan-Americano Bank, Agrenco, and other cases. Right now, we don't know what's going on because allegedly Bovespa is conducting arbitration in those cases, but we don't know anything, I'm sorry, because it's confidential. And if it is confidential, the problem is that the market will never get access to what was really decided. And therefore, you don't generate deterrence, because if I don't know what they decided, so, I mean, why will I, controlling shareholder, be afraid? Because it provides no signaling effect. We don't know which actions are considered to be wrong and are really punished, and we don't know which actions are considered to be good. So that creates a problem of asymmetry information that is very, very, in my opinion, is completely the wrong incentive you want to provide to a capital market system where players with no ex ante, the type of actions they are forbidden to do, or if they engage in those actions, how they would be punished, so they can not incur in those practices. So if that's the development that's now, you've mentioned that's more on consuming cases, but it happens, and of course I'm not a consumer scholar, so I will not make an adventure in that area. But in corporate law, that would make me very concerned. And as also to address Morgan's points regarding the development of the doctrine in the US case law, so I have been studying this recently. And it turns out the major case precedents in Delaware, they are all connected to the kind of information that was revealed in discovery or during companies' internal investigation or exchange of documents between parties and deposition. So this really makes substantive law close to market practices if you get access to what's going on inside the corporation. So if that happens, I'm going to be concerned, because I think it can be detrimental to market development, and it's exactly the problem Brazil has nowadays. We don't know what the arbitration panel of Bovespa has decided. Everything is kept secret. They say they are going to release a summary of the case, but even though nothing has been done until now. So investors don't know.
Professor Erica Gorga, I would like to question you about your opinion on the possibility of Novo Mercado adopting special rules for procedure of discovery in a pre-trial, for example, before an arbitration about gross M&A operations, but with a private procedure of pre-trial, a private arbitration mediated by a third neutral party in where the discovery could be made and everybody could have access to all the documents, but the company could also give its statement on those documents. Because I think that here in Brazil, another principle that is really important in our civil procedure is the idea of contraditório, that the both parties must say up anything or everything about the documents that they are showing, and they have this right. But this could be done in a pre-trial, a private pre-trial, private pre-arbitration. I would like to know your opinion about it.
Well, I think, yes, that's an idea. I mean, we don't know how we could implement it specifically, but of course, companies could opt to have a system where they could, in arbitration, actually, you see this clause that sometimes the judgment will rely on equity and not on formal law. So why not? You can have another clause saying, you know, we are going to allow more extensive discovery. I think that's one possibility, and should really welcome those types of changes in Novo Mercado rules. I'm not sure whether the companies will like, though. Okay.
Hi. I'm actually just to complement a point made by Professor Morgan, that he was in doubt on whether the statistics on financial litigation here in Brazil actually is something that is overwhelming comparing to other countries. So I have here at hand that in 2010, there were 86 million lawsuits in the Brazilian courts, and just new lawsuits from 2009 to 2010 were 24 million lawsuits. So if you apply the percentage to this huge number, I worked previously in a bank, in a large bank here in Brazil, that had in its portfolio something around 350,000 lawsuits. So this is actually these are extreme high figures. I don't know in comparison to other countries, but if you, in addition to that, you put the low resources of the Brazilian courts in terms of judge per population and all the other institutional difficulties that come together, I think that this institutional argument that Professor Salama wants to make in his text actually would have a sense. And my question to Professor Salama would be, if in the case of Brazilian financial litigation, some people try to portray it, and you actually said that this can be quite reductionist, that the judges, they are pro-consumer and they are anti-bank. And then in the text, exactly the point you're trying to make, that there are some sort of institutional aspects that actually explain this better. But my point is, what do you think about this on the society, the organization of consumer associations or the Ministério Público in Brazil, and the role they play in fostering or actually being some sort of vocalizing consumer demands before the courts? Do you think that, what is your opinion comparing, for instance, to class actions or some sort of other collective actions that are well developed in the United States? What is your opinion on how society is organized to fight against banks, so as to speak, in the judiciary system?
So to answer your question, Caio, let us use some unorthodox language that is used just to present a caricature of the credit market in Brazil. With the levels of credit that we have in Brazil, it is not totally true. It's almost true that people that take credit in Brazil are lunatics or desperates. And the technical term for that is adverse selection, right? And there is a paper I mentioned by Paulo Furquim and Luciana Jung that thoroughly documents that this is now an acceptable story, that high levels of interest rates are causing deep problems of moral hazard, and therefore the kinds of creditors that we have in the credit markets are lunatics and desperate people. And if you add, so the question then is, where do you place lunatics and desperate people in the largest cadre of the institutional framework for protection of debtors in Brazil? And you end up placing them in a situation where they have, how do I frame it? They have grounds to seek special protection because they are lunatics or desperate. And therefore, the way you have to read the movement for protection of debtors in Brazil is in many ways the movement to protect these kinds of debtors.